Hello and welcome to Jurisage Academy's YouTube channel. Today we are going to talk about a very important thing, that is case laws and their importance for CLAT PG examination. So in this video we have come up with 10 important recent judgments which are very important for constitutional law, and there's a high probability that they will be asked in CLAT 2024. So let's start and see what these judgments are. But before we begin, we have an important announcement. We have launched two books. One is of CLAT PG mock book and the other one is case book. You can pre-order these at the price of 4599. The link is given in the description as well as on your screens. So now let's come to the first judgment. The first very important case for CLAT 2024 is Anup Baranwal versus Union of India. This very important 5-judge bench decision has come out in 2023, and this is about appointment to Election Commission of India. So Article 324 tells us that Election Commission of India and the Chief Election Commissioners will be appointed by the President. But it was made subject to any law which the Parliament will make as to how these appointments are supposed to happen. But since there is no law on this point about the appointment process, and that is why the Supreme Court issued guidelines in this case, because there was no parliamentary law regulating this space. So the guidelines were supposed to be in force up until Parliament makes a law. So very recently, after this judgment itself, a bill has been introduced in the Parliament to provide for the procedure of appointment. Now, the main difference between the guidelines and the bill is that in the guidelines, they have also included the Chief Justice of India in the panel for selection of Election Commission of India. But in this bill, they are proposing to remove CJI from the panel, and the impact is that the independence of the names that will be suggested by this panel may not be truly independent. So please read about this judgment and the aftermath and the bill that has been introduced, because this is a very important issue and very likely to come in CLAT 2024. Now coming to the second case, we have Kaushal Kishore versus State of Uttar Pradesh. This is also a 5-judge bench decision. This is on Article 19(1)(a), the freedom of speech, and the restrictions that can be put on this freedom under Article 19(2). So this is particularly in the context of ministers' right to speech. So a very important case, because in this judgment the court said that no additional restrictions can be imposed on ministers' right to speech which are not found in Article 19 Clause 2. And the concepts of constitutional tort, accountability principles of the government, the members of parliament, members of state legislature, all of this has been discussed, and Justice Nagaratna has also partially dissented on the issue of constitutional tort and accountability. So this is a very important case, although it's on a very settled principle of Article 19(2), but anyway a very important judgment and very likely to come. Coming to the third important case, we have Subhash Desai versus Principal Secretary, another 5-judge bench decision. Now this case is about the rift that happened in Shiv Sena between Uddhav Thackeray and Eknath Shinde. So this is a case deciding the validity of the split, not the split basically, but whether it qualifies under anti-defection and the power of the speaker in matters of anti-defection. So the court in this case has also talked about the powers of the governor, because in this case, the governor of Maharashtra ordered a flow test. So the issue was that whether that decision was taken correctly or not. So the Supreme Court has given a very important and interesting finding that the flow test that was ordered was not correct. But since Uddhav Thackeray resigned himself and actually did not face the flow test, his appointment cannot be restored. So this is a very important judgment in which the court has also talked about the tests which Election Commission of India should apply in determining which party should have the Shiv Sena symbol, because both the factions have currently claimed that they are the real Shiv Sena. Now, related to this, you can read last 2-3 year cases like Shivraj Singh Chauhan, the MP case, Karnataka case, in which anti-defection happened, and you can also read about the history of anti-defection law in general, because this is a very important topic right now. Coming to the fourth case, we have Vivek Narayan Sharma versus Union of India, another 5-judge bench decision. This case is about the validity of demonetization that happened in 2016. So the majority of the judges have upheld the validity. They have said that just because the proposal of demonetization originated from the central government and not the central board as envisaged under 26(2) of RBI Act, that in itself will not make the demonetization exercise illegal. However, Justice Nagaratna has dissented, and her dissent is also very important because she has argued and located that central government does have the power of demonetization. However, it is not under the RBI Act. Central government or the parliament can basically make a law and demonetize, but the same power is very limited available under the RBI Act, and hence this demonetization was not valid. Coming to the fifth case, we have Janhit Abhiyan versus Union of India, another 5-judge bench decision, a very, very important case. Now, this is a 2022 judgment. In this case, the court has upheld the constitutional validity of the 103rd Constitutional Amendment Act. Now, this amendment dealt with the EWS quota, which made changes in Article 15 and 16 of the Constitution. So, 3 judges have upheld the validity. There is a minority judgment of Justice Bhatt and Chief Justice of India Lalit on the exclusion of SC, ST and OBC from this EWS quota. So they have also partially dissented, and they have not argued that reservation cannot be given on economic grounds, but they've argued that you cannot exclude SEBCs, SCs and STs from the EWS quota. So a very important judgment on the issue of reservation. Coming to the sixth important case, we have the case of Government of NCT of Delhi versus Union of India. This is also a 5-judge bench decision in which the issue was between the power tussle between the Delhi's elected government and the LG. So the Supreme Court in this case has held that since Article 239 AA discusses the special status of Delhi, it also says that entry 1, 2 and 18 of state list will not be available to the Delhi's legislature and the executive. But other than that, no other entry has been excluded. So the court has held that excluding the entry of services from the ambit of Delhi's legislative and executive power is not correct. So in this judgment, they have also discussed the special status of Delhi and how it is differently administered than other union territories. So it's a very important case because this is also a very long-standing battle between the clash of Delhi government and LG. Now the aftermath is also very important because right after this judgment, within a week, a ordinance was promulgated, and now that ordinance has become a law which now legislatively excludes services. So we'll have to wait and see what the decision is. But for CLAT 2024, the whole issue, especially Article 239 AA, becomes very important. Coming to the next case, we have Animal Welfare Board of India versus Union of India. In this also 5-judge bench decision, the practice of Jallikattu has been upheld. So earlier in 2015, there was a judgment in which the Supreme Court has banned the practice of Jallikattu and other such sports post that some states have made amendment to the Prevention of Cruelty to Animals Act. Now these amendments have been upheld by the Constitution in this case, and the court has held that there is no precedent to show that Constitution recognizes the fundamental right of animals. So this is also an important judgment so far as this constitutional position is concerned. Coming to the 8th case, we have Central Board of Dawoodi Bohra Community versus State of Maharashtra. A very, very important judgment. This is also a 2023 case. Please pardon the typo. It's a 5-judge bench decision. In this case, the court is basically talking about the practice of excommunication practiced in the Dawoodi Bohra community, which basically means throwing a person out of your religion. So in this case, although the issue has become a little redundant because of some developments, because of a new law, but the court has still held that excommunication is subject to constitutional morality and it results in civil death. So this issue is very important, and even though theoretically it has become redundant, it still is important to be decided. So that is why they have referred it to the 9-judge bench, which is going to hear all the other appeals with respect to religious matters that come under Article 25 and 26. So this 9-judge bench and the issues which have been posed before this 9-judge bench are very important. Please give them a read along with a good summary of the 3 very important cases. One is Triple Talaq judgment, second is Sabrimala judgment. Now this 9-judge bench is actually a review of Sabrimala judgment itself, and the hijab ban case, which is Aishat Shifa case, which came out in 2022. So in general, right to religion, Article 25, 26, landmark and recent cases are very important for you. Coming to the last second case, we have All India Judges Association versus Union of India case. Now this is also an important case. It's a 3-judge bench decision which is about judiciary, especially subordinate judiciary. So the Supreme Court has given some guidelines, and the court has said that district judiciary should not be called subordinate judiciary, and they have said that judges are not employee of the state, and the independence of district judiciary is also part of the basic structure of the Constitution. Coming to the last case, we have Icon Education Society versus State of Madhya Pradesh, which is about minority institutions. So in this two-judge bench decision, the Supreme Court has discussed some important cases on Article 30 and the power of minority under Article 30. They've also discussed what is the extent of regulation. How much can we regulate minority institutions under Article 30 and for what purposes? So this is also a fairly important case and very likely to come. So with this, we have come to the end of 10 very important cases for constitutional law. We'll be also releasing these lists for other subjects. So please stay tuned. And if you like this video, please like, share, and subscribe to our YouTube channel.